Hello, my name is Janette Levey Frisch. I am an employment attorney and I use my knowledge of employment law to work with employers like you to craft appropriate, proactive solutions to your workplace challenges. I'd like to welcome you today to the inaugural episode of Ask the Employer's Lawyer. I will be answering each week one employment law question commonly asked by employers, or maybe even one of your questions if you play your cards right, in approximately the space of a 5-minute clip, give or take. Now, I have to dispense with some formalities before we jump into our question. So, here they are. It's known in legalese as issuing a disclaimer. Here's the disclaimer. Answers to questions are not, repeat not, legal advice. They do not create an attorney-client relationship. They do not replace consultation with your friendly employment counsel. Okay, we're done with the disclaimer. Let's get into our question. Are you ready for the first question on Ask the Employer's Lawyer? Okay, here it is. This week's question comes from Linda, the leave administrator. Now, as you can guess, names have been changed to protect privacy, to protect the innocent, to protect, well, everyone. Okay. Here is the question from Linda, the leave administrator. I recently received a request for medical leave from an employee who wants to take, or says she needs to take, 4 weeks off to have and recover from surgery. But she says she does not want to take FMLA leave. She says she'll take her paid vacation time, and she's accrued 2 weeks, and she'd like to take another 2 weeks unpaid, but she doesn't want it to be FMLA leave. What should I do? Can I do that? Should I do that? Somehow that doesn't feel right. I don't feel comfortable with it. So what should I do? Thank you, Linda, the leave administrator, for a great question. I actually get that question fairly often. So first, to answer, can you do it? Well, you can. Should you do it? In my opinion, no, it's not a good idea. It really, most of the time, will only result in trouble for you and confusion for everybody. Why do you designate someone's leave as FMLA leave? You do that so that that 12-week clock starts running on how much time that employee has and also how much time you have to reinstate the employee to their job. You have certain responsibilities under the FMLA and the employee has certain rights under the FMLA. And the employee is, in taking medical leave, assuming that you have 50 or more employees in a 75-mile radius, assuming the employee worked for you for at least 12 months and 1,250 hours in the preceding 12 months, assuming that's met, then time off to have and recover from surgery is a qualifying reason under FMLA. This employee is, in fact, exercising or attempting to exercise rights that she would have under FMLA. So my recommendation is that you nicely tell the employee that you understand her concerns, but that your policy, the company policy, is that when a request for medical leave qualifies as an FMLA leave request, that you in fact do designate it as FMLA leave, and that your company is very conscientious about fulfilling its obligations under FMLA and making sure that her rights, and all your employees' rights, are protected under FMLA. Now, why should you do that? What happens if you don't designate this employee's leave as FMLA leave? Well, first of all, if this employee now takes leave, 4 weeks time off, right? And she comes back to you later and needs more time off for medical leave. Guess how much FMLA leave time this employee is entitled to? 12 weeks, because you never designated that prior leave as FMLA leave. So now what happens is your employee could be out for a total of 16 weeks within a 12-month period. And now you're without an employee, and you have to hold that employee's job open for that amount of time. So it might be a nice thing to do what the employee wants. Now, if your company has policies that provide more than 12 weeks time off, that's another story. But assuming you don't, then my recommendation is that you designate that leave as FMLA leave time. In fact, what I would also suggest you do, I go one step further. Go on to the Department of Labor's website. That's www.dol.gov. And they have forms, FMLA forms, and you download them. And one of them is Notice of Rights and Responsibilities under FMLA. Print that and you give that to your employee. By the way, some courts would say, and the Department of Labor has taken the position that you have to designate that leave as FMLA leave. So you download and you print that notice. You give it to the employee. And the next thing you do is you give that employee the certification forms. You'll see that those forms are on the DOL's website as well. So the certification from the healthcare provider, you give that to the employee. You have the employee get that filled out. And they have to get that back to you within 15 calendar days. Once you are satisfied that you have enough information, that the employee is eligible for leave, and that the medical information confirms that she has a qualifying reason for FMLA leave, you then download and print and give to the employee what's known as their leave designation notice. And then that 12 weeks starts running. The clock starts running from the first day that that employee takes leave. And this way, you eliminate confusion. And then there's no question that this employee, this is FMLA leave. There's no is there or isn't there. And there's no question then if the employee eventually wants additional leave, well, these 4 weeks are subtracted from the 12 weeks. And then you know that it's only 8 more weeks in that 12-month period that you have to allow that employee to take off. That's again assuming that your company doesn't have other policies that are more generous than the FMLA. I hope this clears a few things up for you. If you like the contents of this video clip, then give it a thumbs up, which I think you can find the button somewhere over there, roughly, and spread the love. Share it with your friends and colleagues. And finally, well, not finally, but next, hit that subscribe button and ring the bell over there. And then, finally, let me know. What are your questions? Do you have any questions for the employer's lawyer that you want to ask the employer's lawyer? Let me know in the comments section below. And until then, this is the first episode of Ask the Employer's Lawyer. Again, my name is Janette Levey Frisch, and I am signing off for now. See you next week.